students, let us understand what has happened in the past week in the section of Polity and IR. Here we have few articles dealing with the polity, article dealing with US-Iran deal, and also an article dealing with the removal process of Prime Minister in UK, because we have a topic called as comparison of Indian constitution with that of the world. So we'll also understand how the removal process in UK is different from that of India and what are the lessons that India can learn. First, let us understand the first major debate that has been going on for past some time and is recently reignited, which is called as the Anti-Defection Law Debate. Now, what has happened in the recent past that the members of Trinamool Congress have decided to merge with a regional party known as National Citizen Party of India. And also, there has been a possible defection of Shiv Sena leaders defecting into from Uddhav Thackeray gang into the Eknath Shinde party. Now, we'll understand what is anti-defection law, what is the split versus the merger issue that is highlighted in this article. Because this is a recurrent issue, this can be asked in your mains examination and also in your prelims examination. We'll understand what is the split versus merger, what are the two views regarding the merger, and how paragraph 4 of the anti-defection law creates an issue. So let us understand what has happened. Simultaneous case has happened for TMC and that of also for the case of Shiv Sena, Uddhav Thackeray, basically, where the people have defected into the Eknath Shinde gang. Now, this is basically regarding the paragraph 4, which requires a merger of the original political party and not merely the support of 2/3 legislature. The whole problem arises due to this paragraph 4. We'll understand what is this paragraph 4 and how the decision of the speaker is final in this regard. What is the past precedent? What has the Supreme Court said in its judgment? We'll understand all of it. But before we start, what is the actual problem? Let us see what is anti-defection law all about. So anti-defection law was not originally provided in the constitution. It was later on added in the constitution. We all know that it has been added from 52nd constitutional amendment. And it was done in order to prevent the defections that were having from one party to another. Now, what does anti-defection law says? That a person will be losing his membership in the house if it defects from one political party to another, and there are certain conditions that have been provided. Let us see that condition one by one. The first condition is that if an elected member gives up his membership of a political party voluntarily, so if I am elected from political party A, after getting elected I decide to switch to political party B, I will be disqualified. Second, if he votes or abstains from voting in the house contrary to the direction that has been issued, so a 15 days time period has been given, where I have to inform if I do not want to vote on the same line that my political party is voting. If I vote contrary to the whip issued by the political party, I will be subjected to disqualification. Then, if any member who is independently elected joins any other political party, an independent candidate, which in Hindi we called as nirdaliye, if he decides to join any political party, he will also be disqualified, because the voters might have chosen that candidate only for the reason that he is not contesting from any political party. So getting elected as an independent candidate and then joining a political party also will lead to what we call as disqualification. And the last is, if any nominated member, belonging to any political party, decides that he will join a political party after the expiry of 6 months, then he will also be disqualified. The same thing, the same anti-defection law also tells that the decision of the presiding officer will be final. And this is where the problem begins. The anti-defection law originally also had a merger clause which was in the form of split. Now the split word was changed in the 91st Constitutional Amendment Act, meaning thereby the anti-defection law will stop retail defection, but through the merger clause that was added through the 91st Constitutional Amendment Act, replacing the split clause, allows for merger of one political party into another. So if a single member decides, if I decide to join any political party, I will be disqualified. But if a large number of people, 2/3 of the people decide to join another political party, they will not be disqualified. and this is where the problem starts. This is listed in paragraph 4. Now we'll understand what is the problem of the merger and why it creates a problem. So we have seen and discussed about the exceptions under the anti-defection law, where 2/3 of the legislature of a political party decide to merge into another party. The main question is that who are these 2/3 members? Whether these are the 2/3 members of the original party, which is registered with the Election Commission of India, or these are the 2/3 members who are now part of legislature. The whole question is regarding this, because paragraph 4 clause 1 talks about the original party and paragraph 4 clause 2 talks about the legislature party. So there is a discrepancy in the law, and this loophole in law is being utilized by the members who are defecting from one group to another, and the decision originally rests with the speaker or the presiding officer, which basically decision is also final. Though it is subject to judicial review, we'll come to that. Let us understand what has happened. So the core issue is, does a 2/3 split within the legislature automatically amount to a valid merger, or must larger political party itself merge? So whether the original political party should merge or whether only the 2/3 of the member of legislature should merge, this is the larger question. Now, what is it saying? A subsidiary issue is that the legislature party versus the original party, the 10th schedule treats these as connected but non-identical entities. So legislature party is different from original party. I have told you earlier also, original party is the party which is registered with the Election Commission of India. Legislature party is the party of the people who are basically represented in the legislature. So a party, TMC, is very big. TMC has certain members who are basically part of member of parliament. So whether we are talking about the original party of TMC or whether we are talking about the legislature party, that is who are the members of member of parliament, we are talking about that. This basically becomes the issue. Let us understand what is basically it is saying. So the whole contestation belongs to this paragraph 4. What is this paragraph 4? It is the merger exception. What is it saying? Let us understand. Paragraph 4 clause 1. Disqualification does not apply where a members of original political party merge with another party. So this will not be considered as disqualification if 2/3 of the members of original political party joins or merge into another political party. This will not attract defection or disqualification under the 10th schedule. Then paragraph 4 clause 2 says, such a merger is deemed to have taken place if and only if not less than 2/3 of the legislature party agree. Now this is the discrepancy. 4:1 they are talking about original political party, and 4:2 they are talking about legislature party. This is where the whole bone of contention is in the present case also. This is the only issue that we see, that what is about this legislature party. Both those who accept the merger and those who refuse it are protected. Now what is the key terms here? Original party, I have told you earlier, it is the body that is registered with the Election Commission of India that fielded the candidate, and legislature party is only that party's members in a particular house. So legislature party is basically the members who are basically member of legislative assembly or member of parliament, and original party is very broad. It includes the original party that has been registered with the ECI. So this is the question here. Now the next thing to understand is whether we have to read paragraph 4 clause 1 and paragraph 4 clause 2 separately or jointly. And this is where the problem begins. Let us understand what is the current scenario, what is happening in the current scenario. Let us also understand that. So the first thing is conjunctive reading. First thing is conjunctive reading, which is favored by the Shiv Sena, Uddhav Thackeray party, and also the original TMC led by Mamata Banerjee and Abhishek Banerjee. They are saying that clause 4, paragraph 4 clause 1 and paragraph 4 clause 2 should be read together. So what are they saying? The original party must first formally merge at the organization level, and then 2/3 of the legislature must agree. Legislature alone cannot create a merger. This is a view of what we call as the Shiv Sena, Uddhav Thackeray and TMC under Mamata Banerjee. What are they saying? That paragraph 4 clause 1 and paragraph 4 clause 2 should be read along with each other. Meaning thereby they are saying that first the original party will merge and then the legislature party 2/3 members will merge. Paragraph 4 clause 2 cannot be read alone other than that of paragraph clause 4(1). Now, what are the other members saying, the people who are defecting? They are saying that they have to be read disjunctively. These are not similar. And this is basically supposed as deemed merger. So they are saying, relied on by the rebels, 2/3 of the legislature party agreeing is itself a deemed merger with no separate proof that the original organization outside the house has merged. So the rebels are saying, the rebel TMC leaders and the rebel UBT leaders, they are saying that 4(2) can be read alone, and if the legislature party members, 2/3 of the legislature party members are saying that we want to merge with any other political party, there is no need for the original party to agree to the same. So the whole bowl of contention is this only. One group is saying that they have to be read together, and another group is saying, no, if the legislature party is agreeing, we can merge with any other political party. And this is where the problem starts. And this is what has happened. This is the same case that has happened in Goa, which is famously known as Girish Chandaukar versus Speaker Legislative Assembly of Goa. In that case, what has happened? The few members of the Congress and other members have decided to merge with BJP. Now, Congress and BJP, both are original parties. They have not merged. Congress has not merged with BJP. Only the rebel leaders of the Congress had merged with BJP. So the member of legislature party, member MLAs have merged with BJP. Not the original party, Congress or BJP has merged. So what it was saying, that holding that a deemed merger had occurred. So what did the speaker say? That a deemed merger has occurred because the defectors comprised of 2/3 of their legislature party, despite there being no formal merger of Congress and BJP organization. So what did the speaker favor? Speaker here favored, because speaker is the ultimate deciding authority. Speaker here favored that a deemed merger has taken place, and paragraph 4 clause 2 does not need to be read along with paragraph 4 clause 1. So there is no need for merger of original parties. Even if the 2/3 members of the legislature party are agreeing for the merger, we will follow that. And this is what has happened. This was further challenged in the Supreme Court. The status of the Goa precedent is that it is contested and pending before the Supreme Court, but not stayed. So Supreme Court has not stayed the decision of the speaker. It is still being contested. The Supreme Court is yet to give any judgment on the same. So this is what has happened, and this is where this loophole is being exploited. Presently also we have seen it in the Goa case, and presently also this loophole is being used in the TMC case or in the Shiv Sena Uddhav Thackeray case. Now, let us understand the other judgments that have been given that are associated with 10th schedule. One is that of Kihoto Hollohan, very important judgment. What it has said, that the speaker act as a deciding authority on whether the merger has taken place or not, or disqualification has taken place or not. But this decision is not final. This can be challenged under judicial review. So the decision of the speaker or the presiding officer is also subjected to judicial review. This is the only thing that we need to know about this case. Then Ravi Nayak versus Union of India case, it says that voluntary giving up membership is wider than resignation, and it can also be inferred from the conduct. So voluntary giving up membership, suppose I am a member of a political party. I am not giving up my membership, but I am doing anti-party activities. I am not following what the party is telling me to do, or I am not voting in the same manner where the party has told me to vote. So it is showing my conduct, that my conduct is anti-party. So it can also be included under the voluntary giving up of the membership if my conduct is anti-party. This was said in the Ravi Nayak versus Union of India case. Then, very important judgment that is there is Subhas Desai versus Principal Secretary 2023, which was given by CDI DY Chandrachud. Let us also understand what they have written. In this, they said that the political party and the legislature party are distinct. The legislature party has no independent existence, meaning thereby original party and legislature party are distinct, but the legislature party comes from within the original party only. So legislature party has no independent existence. This is what they have clearly told. But still, they have not given an open judgment regarding whether they will nullify the order of Goa Assembly or not. That is still pending. Then the second thing they are saying that the power to appoint the whip and the leader belongs to the political party, not whoever commands a house majority. So the power to appoint whip and the leader belongs to the original party. They are also saying the same, not whosoever commands the majority in the house. And third, the speaker must identify the real political party using party constitution and leadership structure, not a blind appreciation of numbers. This is not a game of numbers, but something more. This is what D.Y. Chandrachud had said in the judgment. That he said that it is the responsibility of the speaker to identify which is the original party and then decide whether this merger should be allowed or not. It is not just mere that there is a political party and they will give the decision that 2/3 members have decided. But these are just Supreme Court findings and this is not followed in reality. In reality, what is being followed? That paragraph 4 clause 2 can be read separately from paragraph 4 clause 1. And when it can be read separately, we can here conclude that deemed merger has taken place. This was followed in Goa. This has been presently followed in TMC case and also the Shiv Sena case. So this is where the whole debate is. Now we have to wait what Supreme Court will basically give the judgment in the Goa case. And this discrepancy that is arising because of the problem in interpretation has to be solved. So this was the first article that we have discussed. And the second article that we need to discuss is basically the deal that has happened between what we call as the deal that has happened between US and Iran. Let us see what are the conditions of the deal. Now first we will understand what are the conditions of the deal and then we will understand what is the importance of Iran for India and what are the challenges that India faces in dealing with Iran. Some of it is bilateral and most of it is multilateral issues that is plaguing India's relationship with Iran. This can be asked in your mains examination, in the upcoming mains examination, particularly very important for India's relationship with whole of the West Asia. So let us understand what it is saying. What is the US-Iran deal talking about? War termination, end of hostilities on all fronts, including Lebanon. So this is where the deal might not hold because Israel is continuously attacking Lebanon. The deal was also signed in Switzerland. So the firmness to end hostilities on all fronts, including Lebanon, removal of US naval blockade, passage through the Hormuz Strait, and this is basically Iran will also remove its any kind of blockade that is there. Sovereignty, Iran has made sure that there will be no interference in the internal affairs. Trump's regime change policy, so Iran has made sure that if you basically try to intrude or do anything into Iran, this will basically be amount as interference. So Iran has also secured itself the sovereignty clause wherein no interference in the internal affairs of the country will happen. Economic relief, this is where it is again contested whether, because both the side, Iran is claiming that we will get the damages and then US is saying that they will not get it. So we have to see what will happen. $300 billion reconstruction plan, this is basically also being allowed, and unfreezing of the Iranian assets that have been blocked. Around $12 billion of Iranian money is tagged into different parts of the world. So this money will be unfrozen. Iran will not procure or develop nuclear weapons. This has been what Iran has been saying. They have been a signatory of NPT also. They have been saying that we do not want to produce nuclear weapons. So I don't believe what Donald Trump has achieved through this deal. All of this was already a part of JCPOA, which was signed much earlier in 2015. Mutual consent extension of 60 days window, implementation monitoring mechanism, and UNSC resolution to endorse the deal. So this has what broadly the points have been made in the Iranian deal. Now, the next thing that we have to understand is what is the importance of Iran for India. What is the strategic importance of Iran for India? The first is that of geostrategic location. Iran is located between the Persian Gulf and the Caspian Sea, controlling the northern flank of Strait of Hormuz, where it is roughly 1/5 of the world's oil and quarter of seabed crude transits. So 20 to 25% of the all crude oil that the world transfer happens through this route of Strait of Hormuz, and we have seen that it led to increase in oil prices in India. India also has to increase the price of commercial LPG cylinders because of the shortage. So this is very important for India's energy security. India is an energy deficit country. It is dependent on the foreign countries for the imports of crude oil and gas. So any impact will basically create a problem. So Iran sits at geostrategic location, and Iran is also important for India's energy security. It also provides India a gateway to Afghanistan. Basically, Afghanistan is a landlocked country, but Afghanistan is very important for India in order to basically keep a check on the activities of Pakistan as per the Mandal Siddhant, where your neighbor is not your friend, but your neighbor's neighbor is your friend. We have made tremendous investment, close to $3 to $4 billion of investment we have made in Afghanistan, though it has been turbulence because of the regime change in Afghanistan. So we have to also say that. This is also very important for the functioning of INSTC corridors. So it is very important for all these things. Energy security we have already discussed. Counter China-Pakistan axis. So we were developing Chabahar Port as a response to the Goa Port. So scholars have dubbed it as Chinese string of pearls theory, where it is trying to encircle India. And we are basically contrasting the CPEC with our own investment in the Goa Port, with our own investment in the Chabahar Port. So we are trying to alter the Chinese investment in the Goa Port as a part of CPEC by our own investment in the Chabahar Port in Iran. So this is also very important to counter the aggressive rise of China. Then West Asia particularly is very important for remittances. So any disturbances in the West Asian region will impact our diaspora that is living there, and also impact the crucial remittances that India receives. Let me remind you that India is the world's largest receiver of remittances in the world. It has crossed more than $100 billion in a year. And next is India has launched some initiatives like that of IMEC, India Middle Eastern European Economic Corridor. So this will also be very important, that the success of IMEC will depend upon the regional stability of the Middle Eastern region. So we can only succeed if Iran basically is not into conflict with US and that of Israel, both of which are now seen as Indian friend. This brings us to the next part of the discussion, that what are the issues that are the challenges that are plaguing the India-Iran relations. What are the challenges that plagues the India-Iran relations? So we have to also understand that what are the challenges in the India-Iran relations. The first challenge that we can understand in the India-Iran relation is that the India-Iran relation faces the problem because of the problem of the maximum pressure policy that is being applied by the US. The US follows a maximum pressure policy on Iran, and this has been reignited in what we call as the Trump's regime. And this is basically creating a problem for India. So what has happened, that under the Trump 2.0 administration, they have implied maximum pressure regime. India is seen close to US, and India has basically relationship with Iran, though it was decreased very specifically, but it creates a problem. And because of this maximum pressure policy of Trump that it levied on Iran, it created a problem for India, that India has to withdraw its supports in the Chabahar Port development. This was for the first time that Indian budget did not officially allocate any money to the Chabahar Port. India was looking for a partner in Iran so that it can transfer its ownership in the Chabahar Port to any Iranian party. Next, India has very good relationship with Israel. We have entered into a strategic partnership with Israel. The closeness with US and Israel is basically driving India away from Iran. Then the problem is Iran is getting much closer to China. They have signed a 25-year deal where China is being supplied with Iranian gas and crude oil. China remains the #1 receiver of Iranian gas and crude oil, and this basically is creating a problem for India. Then Iran has also offered Bandar-e-Abbas port to China. Iran has also entered into a partnership with China where they are jointly exploring the possibility of nuclear peaceful use technology. So what is happening, that India is getting closer to US and Israel, and Iran is getting closer to what we called as China. Iran has also entered into a multi-year, 20-year partnership with Russia. So the Russia-China-Iran axis is getting stronger. Now they are also getting the membership of SCO. So this axis is becoming stronger, and these three countries are basically against the US domination of the world affairs, and they have been very vocal about the same. So this has been creating a problem for India in the long run. And then any disturbance that Iran creates in the West Asian region, so Iran has been labeled that it basically provides support to the rebel group, whether it is Hamas, whether it is Hezbollah, or whether it is the Houthi rebels in Yemen. What it all does, it basically deteriorates the security situation in the Middle Eastern region. And this region is important for Indian diaspora, India's energy security. So ultimately, Iran is not targeting India, but India is getting impacted because of the instability in the Middle Eastern region. And in the past, Ayatollah Khamenei has made some statements in India, particularly after the abrogation of Article 370. So Kashmir issue is also a reminiscent of the same problem. So this is also the challenges that India faces with Iran. So this was about India and Iranian relationship. Now what India can do, India has to basically reinvigorate its partnership with Iran. India needs to get the waiver from the US that it needs to partner with Iran. Now the Iranian sanctions are being lifted, so India needs to restart its oil policy so that diversification can also happen, and then we can cherish the civilizational ties that we have with Iran. The role that has been currently played by Pakistan, India could shoulder the responsibility, because India has good relationship with both US and we have civilizational ties with Iran. So India can leverage this partnership, bring them on the negotiation table. Already they are on the negotiation table. We can ensure that this 60 days peace process is transformed into a long-term peace process. India having good relationship with Russia can also leverage that partnership. So India needs to leverage its partnership with Iran, restart all the projects, whether it is INSTC, whether it is Chabahar Port development. India cannot give up on Iran, or Iran is very much important for India, and Iran is also ready for its partnership and the support that India offers. So we can build upon that partnership. Now the screen is working up, so let us understand the next article. I'll also make you understand the next article. The next article is the resignation of the UK Prime Minister Starmer recently. And in the past, 7 Prime Ministers of UK have resigned. Now the topic basically that I had to discuss with you was the resignation of UK Prime Minister and comparing it with the Indian Prime Minister. Let us see what has happened. UK does not have a codified constitution. UK does not have a codified constitution. This topic is important because of comparison of Indian constitution with the world constitution, and this topic can come in this year mains examination because they will see issues like this. So what happens in UK? UK does not have a codified constitution. They run on convention. India on the other hand has a codified constitution. We have borrowed the Westminster form of parliamentary democracy from UK. There is no doubt about that. We have borrowed it from them. But there is a difference. There is a difference in the process where the Prime Minister can be removed. UK does not have a codified constitution, so they are run by convention. Whereas the Indian Prime Minister is strictly governed by the provisions that are written under Article 74 and also under Article 83, though not related to the Prime Minister, but it is talking about the tenure of the Lok Sabha, which is 5 years. But in UK, 7 Prime Ministers have resigned in the last few years. So why this has happened, let us understand that. So in UK, as per the convention, there is a lot of power that is given to the backbenchers members of parliament belonging to the same political party. So what has recently happened? That the members from the same Labour Party to which Starmer belonged, 20% of the members, the 20% of MPs belonging to the Labour Party can basically initiate a resolution to remove the Prime Minister. So the party is itself removing the Prime Minister in UK. It is not about the stability of the government. The government will still belong to the Labour Party. But what is happening that the members of the party, which is reflecting their strength of their inner party democracy, the members of the party members of parliament of the political Labour Party have themselves said that we want to remove Starmer as the UK Prime Minister and he has to then resign. We cannot consider this case in India. In India, this is protected by anti-defection law, where the members cannot go against the Prime Minister. So this clause is not available in India. This is the difference between UK Prime Minister and the Indian Prime Minister. And this in UK is true for both Labour Party and the Conservative Party. It is true for both the things. The Conservative Party is driven by 1922 resolution, wherein they can also decide that we want to remove the Prime Minister if they have the Prime Minister, and the Labour Party has this 20% criteria, 20% rule, that if the 20% of the MPs of Labour Party itself decides that we want to remove the Prime Minister has to resign. This clause is not available in India, neither in BJP, nor in Congress, nor in any other political party, because we have something called as anti-defection law, which prevents the instability that can arise in the party. So for UK, accountability is much more important than the stability. And for India, stability is much more important. So we cannot think of this situation in India. This clause is not present in India. So if we look at UK from outside, we will feel that UK is so much unstable, their prime ministers is continuously changing. But this is not bad, because it reflects inner party democracy, where the MPs are not satisfied with the leadership of their prime minister, so they are saying that we have to remove him. In India, on the other hand, the entire party is basically PM centric. PM decides who will become the council of ministers. PM decide which portfolio will be allocated to anyone, and the PM cannot be removed under any scenario. An individual minister in India can resign; it will have no impact on prime minister. But the moment prime minister will resign in India, the whole council of ministers and PM will be dissolved. The Lok Sabha will be dissolved. So the entire process in India is PM centric. But the entire process in UK is a collective outbringing, wherein stability is not given the importance, accountability and inner party democracy is given more importance. So this is where India can learn, because we have borrowed the parliamentary form of government from UK. So this is where we can also learn from UK that yes, this is a good thing where we can adapt this. There's no problem in adopting this system. But I will not suggest that India needs to go for adoption of this, but India needs to go for one thing. That is the changing in the anti-defection law. There is a need to change the anti-defection law. And this is not only by me. Dinesh Goswami Committee, Law Commission report and various other committees have also said that there is a need to change the anti-defection law, where the inner party democracy can also be protected. Anti-defection law is just not for stability. It was introduced for the purpose of securing stability, but now it has been weaponized as a tool which is basically used to tow all the party members in the same line. Because if anyone will vote, what we have seen in the anti-defection law discussion, that if anyone will vote in contrary to the direction issued by the party, he will be subjected to disqualification. So this is basically like a weapon, a tool, a leash that is being utilized on the members of the political party itself, that they cannot vote beyond the party direction. So we are talking about vibrant democracy of India, where there is no inner party democracy. So these cannot be delinked. So Dinesh Goswami Committee or even the Law Commission report have continuously said that there is a need to change the anti-defection law. Not remove anti-defection law because it is important for stability in the democracy, but there is a need to change the anti-defection law. Next question is, what is the change that they recommend? What is the change that they are recommending that we need to introduce this change in anti-defection law? So they are saying that anti-defection law was introduced primarily for stability. So anti-defection law and the direction that is issued by the party whip, which has to be followed by the members of the political party, should only be followed in the matters of confidence or no confidence motion, in case of money bill, and not anywhere else. In case of budget, in case of money bill, and in case of confidence and no confidence motion. Because if here the government is not able to pass the money bill, budget, or what we call as no confidence motion, the government will fall. So they are saying, Dinesh Goswami Committee or the Law Commission report is saying, when it is a motion of no confidence motion or confidence motion, it is a question of money bill, it is a question of budget, then the party can issue whip, and the party members should not vote against the same. If they vote against the same, they should basically attract the provisions of anti-defection law. They should be disqualified, because these three provisions are dealing with stability of the government. But it should not be retained in case of ordinary bills. In ordinary bills, the MPs belonging to any political party should be able to exercise and cast their vote freely. There the whip direction should not apply, there the party direction should not apply. So that we can preserve the stability, but we can also preserve the inner party democracy. So this is where we can learn from UK, and this is where we can make changes to our anti-defection law such that it preserves the stability by retaining anti-defection law or the whip only in case of no confidence or confidence motion, or in case of money bill, or in case of budget. But for case of ordinary bills, the individual members of a political party can vote in any direction that they want, which will preserve the inner party democracy. So yes, we need to change the anti-defection law such that we can also promote inner party democracy along with that of stability. So these were the major developments in the field of polity and IR during the week. We'll meet again next week and discuss about other issues. Okay, thank you.